About termination of employment?
Yes, and all and any the most important thing you think I should start from the beginning of the hiring stage or the of the employment.
Yes. So if you've run your business properly as far as hiring employees, I think E makes a good point that your termination, everything really starts with the hiring stage. And in fact, I think it starts even before that when you advertise a position. You want to do that properly. You want to make sure that you have a clear job description, and that you invite all the applicants who should apply for the job. And you want to save a copy of that job ad that you put wherever you may have put it, because you may need it later. Something may come up, and you have to draft those properly. And we can get into a lot of reasons why, but it could be for disability reasons. Everyone's going to have sooner or later a disabled employee. And if you don't have a clear job description of what the major duties are of the job, you'll be in a bad position later trying to say that, well, this employee who is disabled couldn't perform the major function of the jobs. We had to let him or her go. So everything starts early in the process with the right job description, the right advertisement for the job. And then when you go to the hiring stage, you want to do everything in the hiring stage properly. You want to make sure you ask the right questions. You make sure that you document things properly, and you don't ask any illegal questions, even if they're innocent enough. Like you may be tempted to ask a female employee, do you plan to have children, or do you have any children that you take care of at home? And you may think that's an innocent question, but that's really a loaded question, because later in the process, if you terminate that person, they may remember and say, well, geez, they asked me at hiring if I plan to have children, and then when I get pregnant, they terminated me 2 months later. I think they terminated me because I got pregnant. And that could be significant liability for the employer if that happens, even if that's not the reason why it happened. So that's why it's important to follow proper protocols and procedures every step of the way. 99% of the time, it's probably not going to matter, but it's that 1% of the time where you have an employee who decides to file a lawsuit. And if you don't have proper procedures for the advertising, for the hiring, for your personnel policies, your handbook, you're going to be in a bad position at termination. But even if you haven't done all of that, all is not lost. If you handle the termination properly, your chances of being sued are greatly reduced. Employers fire employees every day, many times, and most employers don't get sued for that. But there are things you can certainly do to lower your chances of being sued, which should be the goal of any employer. Nobody wants to get sued. So I think throughout the employment relationship with the employee, if there's any performance issues, they should be documented. I think we're going to talk about that today. They should be put in the employee's personnel file. The employee should get a chance to comment on those things, and maybe they agree, but maybe they disagree. But by law, they have to be given a chance to comment on that and write a rebuttal if they want. And if you do that, go through that process, and the employee is in fact not doing well, or maybe you have some other reason for termination, maybe you have an economic downturn, the employee is going to be less likely to want to file suit. It's usually the employees who feel they've been disrespected, in my experience. And I represent both employers and employees, more on the employer side, but I have represented many employees over the years. And I've taken many phone calls from employees who would like to sue their employer. And usually most of those employees feel that they've been wronged or disrespected in some way. They don't have a good relationship with their boss or the owner. And I'm not saying you have to be friends with your employees, but if you treat them with respect, most employees will not sue you. If you're honest with them about their performance, if you're honest with them about the reason for terminating them, I think they're less likely to want to file a lawsuit. And I think you have to be honest even when it hurts their feelings. A big mistake a lot of employers make at termination is trying to save the employee's feelings. Maybe they tell the employee, well, it's not working out, you're not a good fit, or we're having economic difficulties. And sometimes those things aren't true. Sometimes you say they're not a good fit. In reality, they're just not performing well. And I think it's better to be honest, because when you tell an employee they're not a good fit, that could be code for some kind of racial discrimination in the employee's mind. That, oh, I don't fit in here because I belong to a certain ethnic group, or my background or my religion. They're saying that I'm not a good fit. And that's really not what you meant. You were trying to be nice. So it's really better to be honest with the employee about termination, the reason for it, and to document it. And you still are going to have some difficult employees from time to time. I help employers with the most difficult employees. And for those employees, you really need to come up with a strategy and a game plan to terminate them. And that could include, I think we're going to talk about tonight, possibly giving them some severance and trying to get a release in exchange for that severance. And if you do that the right way and you draft your release properly, which means your lawyer drafted it properly, you're going to be in a good position to defend a lawsuit. Now, you may ask me, could an employee sue me for this? Could an employee sue me for that? Even if they signed a release, could they sue me? The answer is always yes. An employee can always sue you, even if they signed a release. Because in the United States and in Massachusetts, anybody can sue anybody. All you have to do is draft a complaint, go to the court, and you have a filing fee, or it may be the case where you go to the MCAD, which is the Mass Commission Against Discrimination. Really, anybody can file any case, and it's going to be up to you to get rid of it. The question is going to be, are you in a good position to defend that case and hopefully dismiss it early rather than have to defend it for years and maybe be on the hook for a judgment? So I said a lot there, E, if you want to start following up subject by subject.
Yes, thanks, Adam. So I see some, I'm sorry.
Can I interject before you go any further? I want to go back quickly to Adam's points about personnel file. And can you just elaborate a little bit on what documents are required by the law to go into a personnel file?
Yeah, I don't have a specific list. I don't know if it's on E's. Eve prepared this nice PowerPoint here. But really, there's a very specific list in the statute of what is going to be in there. And it's really pretty much what you would expect to see in there, is the any kind of application by the employee, the basic information about the employee, their right to work. But what's really important is, as you go along, what you put in there after the hiring. The hiring process, well, it's important to put in there if there is an offer letter, or if there is a quote contract, and we can talk about employment contracts. If you do have a personnel file, I would recommend you have the employee sign a notification that she's received a copy of the personnel file and she's read it and understands it, or someone went over it with her and she understands the personnel policies of the company. And I would put a copy of that in the personnel file. But as you go through the employment, if the employee has any type of disciplinary issues, that could be tardiness, that could be insubordination, it could be just a performance difficulties. Those are very important to document. I think you put it on here. We call that papering the file. And everyone all attorneys kind of know what that means. And we sometimes we even laugh about it. Oh, you're papering the file, you're papering the file. Everyone thinks that means, well, you want to get rid of that employee. You're papering the file because you're setting that employee up to be terminated. That's probably actually true. But in most cases, you're not doing that because you're discriminating against the employee or you're doing something illegal. It's because the employee is not performing, or they have disciplinary issues or tardiness issues, or they just don't show up to work. And it's important to document that. So those are the types of things that's important to put in the personnel file.
Sorry, before Adam continues, just let the people, that audience know that we have a few new audience here, and I just want to let you know, if you have any questions, feel free to type in the chat box, and we will, Attorney Whitney will answer the question at the end of the seminar. So talking about those documents during the hiring stage, for example, you just mentioned the employment agreement and also offer letter, and also as attorneys know that like the handbook is a very important thing. So what kind of document you you think it will be very important for the employer to prepare during the hiring stage, and then what to include in these documents, for example, like the job duties and any performance review policy?
Yeah, at the hiring stage, yes, I think if there, I would put the advertisement for the job. A lot of employers will put that rate in the personnel file. So it's important to go over that, I think, at the hiring stage, and to document this is the position.
Sorry.
And if there is there's usually some type of offer letter, whether or not that's a formal contract or not. There's usually an offer letter from the employer. It's very good practice to have a written offer or a written description of the duties, the pay, and things of that nature. That's obviously important to have at the hiring stage, that this is what's being offered, this is what's accepted. So that's important at the hiring stage. And yeah, like we talked about, I think it's important to, once you do hire the employee, once they are hired and on their first day, is to go over the personnel policies of the company. And I understand a lot of employers may not even have a employee handbook, or if they do have a handbook, maybe the owners really themselves don't even know what's in there because they haven't changed it in years, and I think a handbook is standard. That's a mistake, and I know it's no fun to go through a handbook and change it every year, but you really should do it. You really should sit down with your employees and say, here are our policies. You don't have to go through every single policy. You should go through the most important ones, like sexual harassment and things like that at the hiring stage. Make sure the employee understands that. Make sure the employee understands what their obligations are about showing up, how they're going to be paid. It's very important that they understand how they're going to be paid. And have the employee sign off on that, because you don't want to dispute about these things later. I've seen lawsuits where employees thought they were going to be paid a different way. They bring up an old contract from early in the employment process, and it wasn't well documented. And I've seen lawsuits where employees, years later, they filed a lawsuit, and the employer was in a bad position because it didn't document how the employee was going to be paid. And this is especially true when there's commissions on payments. If you have employees on commissions, you have to take great care to draft an appropriate commission agreement and to document that, make sure the employee understands it, make sure the employee agrees to it, check with your lawyer to make sure it's compliant. What else about the hiring stage? I'm going to look at E's nice PowerPoint here. Reference check. It is important to check the employees' references. And so a lot of former employers, they probably won't give you much other than the employees' dates of employment and the position that they held. That's usually what we tell employers to do as far as a reference to give to an employee. But it is important to check those so you do your due diligence, because as an employer, you're responsible for what your employee does. And that could be in a couple different areas. So if your employee is in a position to potentially cause harm to others, like a good example is if you're a restaurant and you hire a bouncer and you don't check that person's references and the bouncer ends up hurting a patron. This actually happens a lot. You can be on the hook because you didn't perform your due diligence and check this employee's references, and in some cases may even check his criminal background. But you can also be on the hook if you hire a supervisor and the supervisor sexually harasses an employee. That's the company's liable for that. So you want to really check your references of the employees as much as you can and make sure that they're good employees. And as we talked about, have procedures that the employee signs off on and make sure that they understand.
Thank you, Adam. And then I also for the employee number requirements that like for example for the FMLA for some small employers, these probably won't apply to them, right?
Yes, that's a good point, E. We were talking about that the other day in our office, that some employers make the mistake of having a handbook that maybe they found off the internet, or they had someone draft it. They don't really know which employment laws apply. Because as E alluded to, the FMLA, the Family Medical Leave Act, that only applies if you have 50 or more employees. So, and it's very burdensome. So if you have 15 employees, you don't have to comply with that statute, and you really wouldn't want to. It's very burdensome. So you want to make sure that your policies and procedures cover what you do have to comply with, but also that you're not subjecting yourself to statutes where you don't have to comply with those statutes because they're very burdensome. And I see employers make that mistake sometimes. They think, oh, we must have to comply with the FMLA, that's a federal law. Well, not every employer has to. And I think E has it on here for 6 or more employees, you're subject to state anti-discrimination law in Massachusetts, and you have to have a sexual harassment policy. You also cannot discriminate against somebody on the basis of race or religion, sexual orientation or gender, many different things once you're over 6 employees. Now, you may ask me, if you're under 6 employees, does that mean that we can sexually harass our employees? Absolutely not. There's just a different statute that applies. You just don't have to have a specific policy. Once you're over 6, you have to have a policy. And then it goes from there, from 6, every time you have more employees, it may trigger a new statute, which is why we were talking about with Connie and E earlier last week, we were talking about this. It's important to have your handbook reviewed every year, because if the number of employees change at your company, different statutes may apply. If you have less or more, it's going to trigger different statutes. Once you're up to 11 employees, then you have to have paid sick leave, and you have to make sure you have the proper policies for that. Now, even under 11 employees, you have to have sick leave in Massachusetts. It's just not paid sick leave. So there's a big difference. Then I think it's once you get up to 15, as E has here in the PowerPoint, then the federal laws start to kick in. There's another one at 20, federal age discrimination. That's not a big difference because it's already covered once you get to 6 under state. It's just a different body of law, state law versus federal law. So that's not a big difference. But every time your number of employees changes, these things change. And not only that, these statutes change all the time. In Massachusetts, we have new statutes almost every year that really impact the employment relationship. So if you don't have a handbook, if you haven't had your handbook looked at in a year, 2 years, 3 years, you're probably really missing something important, and you could get yourself in trouble, not only with your employees, but with the Attorney General's office. The Massachusetts Attorney General, she has a lot of power over these types of things, and they can investigate, and they can fine you, they can penalize you if you're not following the statutes.
Thank you, Adam. So these are all the very important documents we need to use during the hiring stage, because I think these are like very related to our termination stage. So Adam, walk through us with the termination stage, that what kind of documents and what should an employer do during the termination stage. And also we talk about the personnel record. So do you think we should give the personnel record, I mean, right away during the termination, or like under what kind of circumstances, like to use this personnel record?
Well, I would, as far as the last question, I would only give the personnel record if they ask for it, the entire record. So employees are entitled to see it under certain circumstances. So it's not a secret, but you don't have to offer it to them. You don't have to give it to them. Termination. So I think, as he has here, the last paycheck. So when you terminate an employee in Massachusetts, you have to pay them all of their earned income that day. That could be their salary, their hourly wage. It could be commissions in some circumstances. It could be unused vacation time that they earned. You have to pay them for that. And technically, you have to pay that day. Now, if you have an employee who quits, you don't have to pay them until the next regular payday. So this can impose some difficulties on employers, because maybe payday is on a Friday. You want to terminate an employee right away on a Wednesday. This employee is just so terrible, you want to get rid of him. Sometimes it's hard to get a check ready. Maybe you have everything going through the payroll, and to get a check ready on Wednesday is difficult, but you have to do it. Now, there's one other thing you can do, is you can tell the employee that we're terminating you effective on Friday. You'll receive your last paycheck as everyone else does on Friday, but just don't come in where you're terminated. It's not effective until Friday, but we don't want to see you back here. So that's the way you get rid of a really problem employee, and you follow that strict rule about paying everything that's due. And you also, you comply with the law, and you just maybe have to pay a couple of days of pay that you weren't planning on paying. It's usually a small price to pay, and a lot of employers will do that. I think, as E has here in her PowerPoint, you don't have to give notice of termination. My feeling is it's usually best not to give notice. You really don't want to keep an employee around if you're terminating them. There could be exceptions, and maybe if you're just laying them off because you no longer need the employee and it's not a hostile situation, then in that situation, it may be okay to say, we're going to let you go. We're going to keep you on for a couple of weeks to help the transition. If you really trust the employee, you can do that. In most circumstances, I would say don't give any notice unless you've committed yourself to that in your documents. But hopefully you didn't do that. I know sometimes employers will commit themselves to that in documents. It's really better to just say, unfortunately, you're terminated today, and today's your last day, and get them out of there, because employees who are very disgruntled and unhappy, they can really cause a lot of damage. They may mess with your computer system. They may use the company email to contact customers or other employees, or who knows what they may do. They may steal files. And so you'd rather not have those employees around. So you don't have to give any notice, and I wouldn't give it unless there's a good reason to do so. As E has here, you'll have to give notice of their right to file for unemployment. That's just a short little form that's available from the DUA's website, the Department of Unemployment Assistance. Connie or E can provide you with a copy of that. You'll have to give notice of their rights under COBRA to continue with health insurance. And I would ask your benefits provider to do that, to help you with the COBRA notice, because it's going to go through your benefits people and they work for you. So you can ask them for that. Yeah, as he has here, you should do an exit interview. If there's any company property to return, you should have a checklist. I mean, it's good to keep a record of what the employee may have. Does the employee have a company cell phone? Is there a key fob? Is there a credit card? Is the employee on any company accounts? Do they have any passwords to any software or websites that you're going to need to get and change? You want to change all that stuff. Especially when you're firing a trusted employee. Is there any company documents or information that they have? And do you have to remind them that they have confidentiality obligations? And they have those by law. If you protected your information, they have a legal obligation to not disclose that, but it's better to have some type of written agreement, even if it's at your offer letter, that company information is private and confidential. You'll return it at the end of employment, and then make sure you follow through with that. In extreme cases, you may want to send them a letter, or you may want to have your lawyer send them a letter to remind them of their obligations to comply with that. He has here a non-compete. If they do have a non-compete, it's very important to remind them. We talked about this in the office the other day. A lot of employees forget what they've signed. I have employees come to me all the time and I say, well, did you sign a non-compete agreement? And they say, no, maybe, I don't know. Employees don't remember this stuff. So it's really incumbent upon you as the employer, if you have those types of agreements and you want to enforce them, whether it's a non-compete, a non-solicitation agreement, a confidentiality agreement, you have to be proactive. You have to remind the employee on termination. You have to put it in writing. You should give them a copy of what they've signed, because I'm sure that employees will forget, and they'll forget to tell their lawyers that they've signed these documents. And I see E has some stuff in here about discrimination, protected class, hostile work environment. So those are all things which are potential lawsuits or claims that they could file with the MCAD, the Mass Commission Against Discrimination. Employees don't like to be fired. They usually look for an excuse for why they were fired. Sometimes employees will say, well, the boss just didn't like me. Fortunately, that's not illegal. It's not illegal for you to not like an employee. I mean, I've heard from many employees come to me and say, it was unfair that they terminated me. And I asked them, why do you think you were terminated? Well, the boss was a jerk. That boss he never liked me. That's not illegal. There's nothing illegal about that. But you have to be careful when they're in some type of what we call a protected class. And I think we talked about that before. And really, anybody is in a protected class. Even me as a white guy, I'm in a protected class. If you are firing all the white guys and you are hiring Asian females, I might have a claim. I might say, geez, that proves discrimination. So even I could be in a protected class. But if somebody is disabled, if they belong to a racial minority, and there are not many racial minorities in your workplace, if they're homosexual or transsexual, and they're in the minority, that's a little bit of a dangerous firing, because that person has probably faced some discrimination in their life, and they may think that you're discriminating against them, even if you haven't. So you have to take extra care when you terminate someone in these circumstances. And that's why I say it's important to be honest to people, because if you just try to be nice and you say, well, it just didn't work out, or you just didn't fit in here, or you lie to them and you say, we're eliminating your position. I've seen employers make that mistake. They say, we're taking your position away. No one's going to fill it. And then 2 weeks later, they advertise it on Google somewhere that they're hiring for this position. The employee is going to see that, and they're going to say, aha, I knew it. They discriminated against me. They said they didn't need someone for this position, and then they hired someone who's not in my protected class. And guess what? That's probably what we call a prima facie case of discrimination, which means that just means that's enough to get them into a lawsuit where the courts are going to say, this is a serious suit. Then it's going to be up to you, the employer, to have to rebut that and say, no, we didn't fire this person with discrimination. We fired them because they were not doing a good job. But hey, you told them, you didn't say anything about them doing a bad job. You told them you were eliminating the position. So you can trap yourself into a discrimination claim just by being nice. I've seen employers fall into this trap. So I'm not saying you have to be mean. You can certainly be respectful and polite, but it's really better to be honest with people why they're being terminated. Do you have to give a reason for termination? You don't have to. I think it's much better to do so. It depends on the circumstances. As Connie and I were talking last week, a termination is as much as an art as it is in science. There are certainly laws that you have to follow, but you have to really think about every circumstance. You have to think about what's occurred in this employment relationship. What is this employee like? Is this employee the type of person that's going to turn everything against you? Is he the type that's going to run to a lawyer? So you have to think strategically about those high-risk terminations, and you have to plan accordingly. And that we're probably going to talk about this, but that may include some type of severance agreement could be in order to get a release from that employee.
So Adam, talking about the discrimination, and are they the same situation as a hostile work environment or harassment? So does the employee have like several complaints based on the hostile work environment or like a harassment?
So a hostile work environment is a type of discrimination. It's a different type of discrimination than what we usually think of, but it's a subsection of discrimination. So a hostile work environment is just what you would think it would be. Usually it's a sexually hostile environment, sexual harassment. That's the most common when an employer, especially a supervisor, is harassing, especially a lower level employee. That's the worst case. And it's what we call pervasive. It happens more than once. Maybe it happens once a week. That is a hostile work environment. That is a form of discrimination. Now, they haven't fired that employee. They haven't taken that employee's salary away. They haven't demoted that employee, but they've subjected that employee to an abusive environment. And that employee may even be forced to quit, which we would call a constructive discharge, where it was so bad that employee was forced to quit. She couldn't take it anymore. She couldn't take the boss every day coming in, and the boss said, "Wow, your legs look great, and will you go out on a date with me?" And the employee just said, "That's enough, I quit." Well, they didn't fire that employee, but they might as well have. But even if the employee doesn't quit, it's still discrimination. You can still be held liable. And in that case, the employee can sue for emotional distress. Sometimes they can get very significant emotional distress awards. We've seen awards, $25,000 would be like a base award. If there's really some significant distress, it could be 50,000, it could be 100,000, it could be more. And that employee could also recover their attorney's fees, meaning you pay their attorney for every hour that the attorney works on the case, not to mention your own attorney. So yes, that's a form of discrimination. It doesn't have to be sexual harassment. It could also be racial harassment. If all the white people that are working are picking on the one black person and making some racial epithets and treating the person badly, that could also be a hostile work environment. And again, whether or not they terminate that person or lower his pay, doesn't matter. It's the going in every day and dealing with that abusive types of behavior. It could also be the same for a disabled employee. It really doesn't matter, or a gay employee. And it could even be like telling a lot of jokes. You know, if maybe you're gonna tell a lot of jokes to the gay employee every day, and if you do that enough, that could become a hostile work environment. So that's why you have to have policies really strongly against that. So that is a form of discrimination. Classically, we think of discrimination as either not hiring someone or firing someone because of their protected class, or demoting them, or lowering their pay, or paying less. Maybe you're paying you have Middle Eastern employees and you're paying them less than the Chinese employees. That would be a form of discrimination, even if you haven't terminated them. So it can be anything. Hostile work environment is more of the stuff that they have to deal with on a daily basis.
Does the employee has the right to disclose his salary to the other employees? Because sometimes we'll think, some employers will be afraid that they will find out they're paid differently, or this kind of situation. Yeah,
so now in Massachusetts, they absolutely have a right to do that. Employers used to forbid that, but there's a relatively new statute where employees have the right to do that. And the reason why that is because of the Equal Pay Act, where you have to pay genders equally. Now, we usually think of that as employers pay women less. We always hear statistics, women earn 78 cents on the dollar, whatever it may be. In Massachusetts, it's gender neutral. So you can't pay women more than men, you can't pay men more than women, and it could apply to someone who's transsexual as well. You couldn't pay them less. So it applies to equivalent work. So if two employees are doing the same job and one is a man and one's a woman, you should pay them the same unless there is a specific reason why you're paying one more. There's very specific reasons in the statute that allows you to pay one employee more than the other. And it has to be for one of those particular reasons. I don't have the list in front of me, but you have to follow that. And if you don't, you're going to get yourself in trouble, possibly with the Attorney General's office, possibly the employee is going to sue you and get back pay and attorney's fees. So to help that statute, to help that, because what the Commonwealth of Massachusetts wants to do, it really wants women to be paid equally. And they want people to be able to discuss their salary, because if it's a secret, well, nobody really knows if they're being paid equally. If the employer says everybody has to keep that a secret. And that's, I think, how employers got away with it for many years. They would just say, hey, this is your salary, it's a secret. And I think many people of my generation are probably more likely to keep that secret. We think that's personal. My feeling is the younger generations are maybe a little bit more open to discuss that stuff. And I think employees are now encouraged to engage that. We have social media where they can put it online. If you're a big enough employer, it's going to be on Glassdoor or something like that. So you should really think that your employees are going to find out how much everybody gets paid. And if you're going to pay male employees more than female, especially, that's the real danger zone. But really, any employee of another gender and equivalent work, you've really got to think about that. And it doesn't have to be the exact same position. It can be an equivalent position. So you could have two employees doing similar work. They have different job titles, different duties, but in the eyes of the law, if they're considered equivalent, you would have to pay the genders equally. And you really have to be careful about that.
Talking about the lawsuit, so do you think a severance, agreement, or sometimes we call it separation agreement, would be the good idea for the employer to get a release and keep a good relationship with the employee?
So yeah, separation agreement, severance agreement, they can be very protective of the employer. You have to do it properly because the courts, they really frown on asking employees not to sue. So you have to do it the right way. You have to be very, very specific in your release. And really, you have to have a lawyer draft it because it's too complicated to draft yourself. For example, if we talked about ADEA, that's the Federal Age Discrimination Employment Act, once you're over 20 employees. If you want to be released from an age discrimination under federal law, there's very specific procedures you have to follow. You have to have certain language in the release. You have to have the employee, in particular, have a right to review it with an attorney. They have 7 days to look at that agreement. So you can't set the employee down in your office and say, sign this agreement right now and you'll get 2 weeks severance. If you don't sign it, you don't get anything. Well, that wouldn't be smart to do because even if they signed it and they're over 40, which is considered old, I hate to tell you, under the federal law, you're considered old over 40. That person could sue you. Your release means nothing. And in fact, you probably made it worse by forcing that on the employee because you're violating the statute by doing that. So that's just one example of how your release has to be handled really properly, where the employee has time to look at it. And actually, it's 21 days to look at it, and it's 7 days to revoke it. So even if they sign it, they still have 7 days where they can revoke that agreement. That's probably the most protective example that I have. So, but yes, if you do follow the right procedures, the release and the separation agreement is something that's it's really the gold standard to get you out of a lawsuit. And like I said, it doesn't mean an employee can't still sue you, but you have an automatic defense. So if an employee signed a well-drafted separation agreement and that employee files a lawsuit, your attorney should be able to get that dismissed very quickly, with the only exception being if the employee said, I was under duress to sign that. So that's why I say it's always good practice to not, even if that statute doesn't apply, to not force that employee to sign right then and there. You always give the employee time to take the separation agreement home, review it with a lawyer. There should be language that says it can be reviewed with an attorney of your choice. That way the employee can't really legitimately claim duress. And then if that employee sues you, your lawyer can probably get that case dismissed very easily. The reality is, once an employee signs a fair separation agreement, they almost never do sue you. So there's a few routes you could go. Number one, you could have a company policy that we give everybody 2 weeks severance on termination. Some companies have a policy like that, usually bigger companies. If you do have a policy like that, you should also say in the policy that you'll be required to sign a separation agreement at the time of termination. Another way you could go is just to take it on a case-by-case basis. So we talked about this before. If you know that this particular employee is going to be very difficult, going to run to a lawyer, you really need to think about what type of person this employee is. Is he someone that's going to sue? Is he someone that would never sue? And you got to think about your strategy. Connie and I talked about this. There's a lot of different strategies you could take. You may want to have it the employee's idea to ask for severance. Because if you just sit an employee down and you say, you've been terminated, we want you to sign a release, some employees automatically think, wow, I wonder why they want me to sign a release. It must be because I have a great claim against them. And they think I'm going to sue them and win. That's why they want me to sign a release. Or maybe they're going to use it against you. And I've seen employees do this, where they get up and testify in court. They said, yeah, they terminated me. And then they immediately wanted me to sign a release that said I wouldn't sue them. Now, to a jury, that sounds like, well, the employer must be really worried about that employee suing. So you just have to think carefully about how you present the release to the employee. And if it's standard, everybody gets one, that's not an issue, because you can testify that, yeah, that's our company policy. Everybody gets 2 weeks severance, or maybe it's a week for every year that they worked, whatever it may be. And everybody signs a release. That's just our policy. That's not special about this employee. Or if you don't have that, then you can make the employer ask for severance. And maybe you give them a subtle hint and say, geez, we're sorry we terminated you. If you think you want some type of severance, we can talk to the company president. We can talk to our lawyers, let us know. But then if you have the employee asking you for severance, it doesn't look as bad to a jury, it doesn't look as bad to the employee. Then you're in a situation where the employee asked for a separation agreement, your lawyer drafted it for you, and hopefully they sign it. But if they don't sign it, they're the ones that asked for it. You didn't offer it to them.
So can we include a non-compete in the severance package? Because I know Massachusetts has a very strict non-compete law. So how can we apply this law to the non-compete if we include in the severance package, or if we have a non-compete during the employment?
Yeah, so you can have a non-compete as part of a settlement agreement or a separation agreement. Has to be drafted in a very particular way, where I think they have 7 days to look at it. They have to have, I think there's language in there, you have to have language that they can review it with an attorney. So again, you can't sit them down on termination and say, oh, we want you to sign a release and also not compete with us. Please sign this right now. Well, if you do that, it's not going to be enforceable. So don't do that. It has to be drafted just right. And that's a situation where it should be enforceable. Now, courts can still look at it and make sure that it's fair and reasonable. So your non-compete still has to be, I think, fair and reasonable. Courts are going to look at how much consideration you're paying to the employee. They're going to look at how long the non-compete is, what you're asking the employee not to do. Is it really protecting a legitimate business interest? So nothing is perfect in the law. Nobody can say for sure if that non-compete is going to be enforceable. But it's not forbidden by the new statute that he's referring to. There's a new statute that makes non-competes much more difficult. This is an exception to the statute, but it's still subject to what we call judicial scrutiny, which means a judge can look at it and say, I don't like it, and here's why. So you got to be careful about how you draft it.
So what, oh, Connie, go
So
ahead.
we have a question in, so it's the same subject as non-compete. So that we're just going to bring up here. So someone is asking a question: if an employer is going to terminate an employee and want that employee to sign a non-compete, is the employer obligated to offer 6 months pay in exchange for that non-compete?
No, there's no, not in that situation. There's no specific requirement of 6 months pay. There does have to be some kind of consideration. I would say the consideration should be reasonable to what you're asking them not to do. If you're paying them 1 week and you're asking them not to compete for 6 months, a judge may not like that and it may not be enforceable. But the 6 month rule, that doesn't apply in the situation of a settlement agreement. That applies in a situation where you're hiring someone or you're asking someone to sign a non-compete during the time that they're working for you. And I think we're talking about the garden leave provision, which I don't know if you want to get into that. It's kind of beyond the question. But.
Okay. Adam, talk about the last paycheck upon termination. So if the employee is a salesperson and he's paid a combination of base salary and a commission, so upon termination, is the employer also obligated to pay him all the commissions due, even though they might have an agreement stating that the employee's commission is paid upon the employers collect all the sales revenue from the customers, and at the time of termination, not all the revenues are collected?
Yeah, so that's a very great area. So the way to protect yourself is to very clearly define how a commission is earned and when it is due. So I would say if it's not earned yet, if it's not due, you don't have to pay it just because you terminate them. Now, in that situation, you may have to pay them after they're gone, which seems kind of weird. Your employee is no longer working there. But if the employee has done everything that they need to do and you fire them on Wednesday and then the commission comes in on Friday and you don't pay that employee, you're very likely to face a lawsuit. You're very likely to lose that lawsuit. And you're probably going to have to pay not only the employee's unpaid commissions, but it's going to get tripled under the Wage Act, automatically tripled. You're going to have to pay attorney's fees. So you start with a very clear agreement on how commissions are earned at every step of the way. It would really be best to have in your policy what happens if someone's terminated. Now, your policy can't control everything, because if your policy is unfair, the judge is going to look at that and say, that's not fair. You're trying to take the employee's commissions away. And in Massachusetts, commissions are considered wages. And wages are special in Massachusetts. They, like I said, triple damages if you don't pay wages. You've got to pay wages normally on the last day, as Connie said. So it's really going to depend on the situation. It's really going to depend on your agreement. And there's really no magic answer to that, one way or the other. You just have to be very careful, and you want to talk to your lawyer if you're firing someone with commissions, and there is a lot of commissions in the pipeline. You know, we usually call it in the pipeline. You know, so what some of my employers do is they just have a fair way of measuring what's in the pipeline. But what they really try to do, even then, is try to get some agreement from the employee. Like, here's what's in your pipeline. Here's what we think you may have a claim to. And that's really when you want to get a very good separation agreement from the employee, because that's a really high risk firing when you're firing a commissioned employee there's money in the pipeline, but you think it's not due. And you can be almost sure that that employee is going to think, wow, I earned that money. Because that's the way salespeople think. They think, I earned that. I should get paid that money. So that's a real dangerous situation. And we see a lot of lawsuits about that.
Okay, thank you, Adam. So this is some great presentation. So I just, now is our question and answer session. So if anyone has any questions, please raise your hand. I think there's a button you can click for raise your hand, but I got a question on the chat box. So it's from Ling Jin. So she asks, like, she worked for a nonprofit organization or NGO, non-governmental organization. So do we need to do the same, I mean, documents or same like a procedure to hire a volunteer?
Well, probably not. If it's a true nonprofit and they're not an employee, I would say no. I'm not an expert on nonprofits. You don't have to go through the same procedure. But you really should think about liability. So if you do have employees who are employees of the nonprofit, you have to think about what exposure you have for those employees. So if you have a volunteer come in and that volunteer, for example, sexually harasses your employees, and you know about that, you could still be liable for that, even if that person is not your employee, even if that person is just a volunteer. So there's a situation where even if that person is just a volunteer, well, you still want to go through the personnel policies and have that person sign off, make sure they understand that you have strict policies against sexual harassment, against racial harassment, and whatever other office expectations that you have. I think it's on a case-by-case basis, but you don't have to go through having an offer letter, a handbook. I mean, the handbook is good, but I mean a contract or anything like that. I think it really depends on what the situation is, what the volunteer is going to be doing, who the volunteer is going to be interacting with. And you should also check with whatever insurance that you have. If you have workers' comp, you should check with your workers' comp insurer. How are we covered for volunteers? If you have a liability insurer, you should check with your liability insurer. What are we covered for if this volunteer is hurt or hurt somebody else or cause some kind of liability? But I would say as far as the procedures for hiring go, they're a little bit different. Some of them would be similar.
Okay. If someone wanted to ask a question in Chinese, that's fine. EOI can just translate it, or you can type in the chat box.
Any questions?
Or you can just unmute yourself and just ask the question. No questions? It looks like all the questions are answered. No questions.
Yeah.
Great presentation. Okay, thank you very much, Adam, and thank you all for joining our seminar. Everyone have a good night. And if you have any subsequent questions, you can either email Adam or email us, and we can go from there.
Okay. Yeah.
Yeah.
Oh.
Thank you.
Thank you.
Okay, cool. Okay, thank you. Okay.
Thank
Bye.
you.
Good night.
Bye. Have a good night.
Good night.